Hello, this is Sophie Hammond and your Patton University online course instructor for this semester. Today we will be in Unit 3, beginning with the overview and introduction. We're just going to read through this together. Now that we understand the basics of insurance as a means of reducing risks, an examination of insurance contracts is essential. Insurance contracts or policies are simply the document received when one transfers risk to an insurance company. One of the most important agency characteristics is binding authority, which secures coverage for an insured without any additional input from the insurer. In order for the document to be legally enforceable, the process must include the offer and acceptance, consideration, and competent parties. Along with this, the contract must have a legal purpose, meaning that the actions described in the contract must be lawful and use appropriate language. The structure of contracts begins with the application, which is the offer to buy insurance, and the binder, which provides temporary coverage until the policy contract is issued by the agent or company. The actual insurance policy is comprised of 5 sections, including declarations, insuring agreement, exclusions, conditions, and endorsements/riders. The declaration identifies the person is covered by the contract, information about loss exposure, and the basis for which the contract is issued. The insuring agreement is a general statement of the promises the insurer makes to the insured, essentially identifying the perils and exposures covered by the policy. Exclusions include the perils, risks, losses, and properties that are not covered by the policy, which provides a sense of protection to the insurer against financial catastrophe as well as avoiding the duplication of coverage. Finally, the conditions section clearly defines the responsibilities of each of the parties involved with the contract, and the endorsements/riders section allows for changes in the policy at a later date. As contracts are an essential part of insurance plans, understanding the basic elements and workings of contracts is central to recognizing how insurance policies are implemented. There are 3 learning objectives for this unit. Number 1, to explain the basic elements of insurance contracts. Number 2, to analyze the differences among selected insurance contracts. And number 3, to critique various aspects of agency law and doctrines affecting insurance contracts. With that being said, we're going to move on to the first objective, explain the basic elements of insurance contracts. And we're going to jump in with the first reading, Requirements of a Contract. When an agent sells an insurance policy, he or she is selling a contract. A contract is an agreement enforceable by law. For any such agreement to be legally enforceable, it must meet the following minimum requirements. There must be an offer and an acceptance. There must be consideration. The parties to the contract must be competent. Its purpose must be legal, and the contract must be in legal form. Offer and acceptance. Offer and acceptance is the process of 2 parties entering into a contract. An agreement is reached only after offer and acceptance between the contracting parties. If the party to whom the offer was made requests a change in terms, a counteroffer is made, which releases the first offerer from the terms of the original offer. In the making of insurance contracts, the buyer usually offers to buy, and the insurer accepts or rejects the offer. When you call an insurance agent for insurance on your new automobile and the agent provides coverage, there is an offer to buy, and the agent has accepted the offer on behalf of his or her company. As stated previously, this acceptance is called a binder. The offer may be verbal, as in this case, or it may be in the form of a written application. This process differs for life and health insurances. Consideration. A contract also requires the exchange of consideration. Consideration is the price each party demands for agreeing to carry out his or her part of the contract. The value of the consideration is usually unimportant, but lacks but lack of consideration will cause the contract to be regarded as a gift and therefore unenforceable. In many cases, insurance contracts stipulate that the consideration is both in the form of premium and certain conditions specified in the policy. Such conditions may include maintenance of a certain level of risk, timely notice of loss, and periodic reports of insurers of exposure values. Conditions will be explained in detail in parts 3 and 4 of the text in the descriptions of insurance contracts. Consideration, therefore, does not necessarily imply dollars. Competent parties. Another essential element for a contract is that the parties of the contract must be competent parties, or of undiminished mental capacity. Most people are competent to contract, but there are exceptions. Mentally ill or intoxicated persons are not recognized as competent. Minors may enter into contracts, but such contracts may be voided or terminated. Upon reaching majority age 18 in some states, age 21 in others, the young person may ratify or reject the contract. If ratified, the contract would then have the same status as one originally entered into by competent parties. A minor who enters into an insurance contract, therefore, may void it during infancy or when he or she reaches majority. Ratification of a policy at the age of majority can be accomplished by oral or written communication, either explicitly or implicitly, by continuing the policy. Some states have laws giving minors the power to enter into binding life insurance contracts on their own lives as young as age 14. Legal purpose. A contract must have a legal purpose. That is, it must not be for the performance of an activity prohibited by law. If it does not, enforcing a contract would be contrary to public policy. A contract by a government employee to sell secret information to an agent of an enemy country, for example, would not have a legal purpose and would be unenforceable. For the same reason, a contract of insurance to cover losses caused by the insured's own arson would be illegal and contrary to public policy and thus unenforceable. Legal form. Contracts may be either oral or written. They must, however, follow a specific legal form or appropriate language. Legal form may vary from state to state. As noted, some insurance contracts are, at least initially, oral. Most states do not have laws directly prohibiting oral contracts of insurance. They do, however, require that some contract forms, the written version of standardized insurance policy provisions and attachments, be approved by the state before being offered for sale. Moreover, the nature and general content of some policies are specified by law. Most states require that certain provisions be included in life and health insurance contracts. Thus, although some contracts may be oral, insurance contracts must, for the most part, be in writing, and they must conform to the requirements of the states in which they are sold. There are some key takeaways and discussion questions. We will be moving on to the second reading in Objective 1, titled Distinguishing Characteristics of Insurance Contracts. In addition to the elements just discussed, insurance contracts have several characteristics that differentiate from most other contracts. Risk managers must be familiar with these characteristics in order to understand the creation, execution, and interpretation of insurance policies. Insurance contracts are the following: based on utmost good faith, contracts of adhesion, contracts of indemnity, and personal. Based on utmost good faith. When an insurer considers accepting a risk, it must have accurate and complete information to make a reasonable decision. Should the insurer assume the risk, and, if so, under what terms and conditions? Because insurance involves a contract of uberme fide, or utmost good faith, potential insureds are held to the highest standards of truthfulness and honesty, providing information for the underwriter. In the good case of contracts other than for insurance, it is generally assumed that each party has equal knowledge and access to the facts, and thus each is subject to requirements of good faith, not utmost good faith. In contrast, 18th century ocean marine insurance contracts were negotiated under circumstances that forced underwriters to rely on information provided by the insured because they could not get it firsthand. For example, a ship being insured might be unavailable for inspection because it was on the other side of the world. Was the ship seaworthy? The underwriter could not expect it, so they were all men in those days, required the insured to warrant that it was. If the warranty was not strictly true, the contract was voidable. The penalty for departing from utmost good faith was having no coverage when a loss occurred. Today, the concept of utmost good faith is implemented by the doctrines of 1. Representations and 2. Concealment. Representations. When people are negotiating with insurers for coverage, they make statements concerning their exposures, and these statements are called representations. They are made for the purpose of inducing insurers to enter into contracts, that is, provide insurance. If people misrepresent material facts, information that influences a party's decision to accept the contract, insurers can void their contracts and they will have no coverage, even though they do have insurance policies. In essence, the contract never existed. Note that material has been specified. If an insurer wants to void a contract it has issued to a person in reliance upon the information she provided, it must prove that what she misrepresented was material. That is, the insurer must prove that the information was so important that if the truth had been known, the underwriter could not have made the contract or would have done so only on different terms. If, for example, you stated in an application for life insurance that you were born on March 2nd when in fact you were born on March 12th, such a misrepresentation could not be material. A correct statement would not alter the underwriter's decision made on the incorrect information. The policy is not voidable under these circumstances. On the other hand, suppose you apply for life insurance and state that you are in good health even though you've just been diagnosed with a severe heart ailment. This fact likely would cause the insurer to charge a higher premium or not to sell the coverage at all. The significance of this fact is that the insurer may contend that the policy never existed, it was void, so loss by any cause, whether related to the misrepresentation or not, is not covered. Several exceptions to this rule apply, as presented in chapters discussing specific policies. In the case of life insurance, the insurer can void the policy on grounds of material misrepresentation only for 2 years, as was discussed in Chapter 1, The Nature of Risk, Losses and Opportunities. It is not uncommon for students to misrepresent their auto insurers where their cars are garaged, particularly if premium rates at home are lower than they are where students attend college. Because location is a factor in determining premium rates, where a car is garaged is a material fact. Students who misrepresent this or other material facts take the chance of having no coverage at the time of a loss. The insurer may elect to void the contract. Concealment. Telling the truth in response to explicit application questions may seem to be enough, but it is not. One must also reveal those material facts about the exposure that only he or she knows and that he or she should realize are relevant. Suppose, for example, that you have no insurance on your home because you don't believe in insurance. Upon your arrival home one afternoon, you discover that the neighbor's house, only 13 feet from yours, is on fire. You promptly telephone the agency where you buy your auto insurance and apply for a homeowner's policy, acting that it be put into effect immediately. You answer all the questions the agent asks, but fail to mention the fire next door. You have intentionally concealed a material fact you obviously realize is relevant. You are guilty of concealment, intentionally withholding a material fact, and the insurer has the right to void the contract. If the insurance company requires the completion of a long, detailed application, an insured who fails to provide information the insurer neglected to ask about cannot be proven guilty of concealment unless it is obvious that certain information should have been volunteered. Clearly, no insurance agent is going to ask you when you apply for insurance if the neighbor's house is on fire. The fact that the agent does not ask does not relieve you of the responsibility. In both life and health insurance, Most state insurance laws limit the period, usually 1 or 2 years, during which the insurer may void coverage for a concealment or misrepresentation. Other types of insurance contracts do not involve such time limits. The reading continues, but we are now going to move on to Objective 2, which is to analyze the differences among selected insurance contracts. And we're going to begin with the first reading, entering into the contract. You may recall from Chapter 9, Fundamental Doctrines Affecting Insurance Contracts, that every contract requires an offer and an acceptance. This is also true for insurance. The offer and acceptance occur through the application process. Applications. Although more insurance is sold rather than bought, the insured is still required to make an application, which is an offer to buy insurance. The function of the agent is to induce a potential insured to make an offer. As a practical matter, the agent also fills out the application and then asks for a signature after a careful study of the application. The application identifies the insured in more or less detail depending on the type of insurance. It also provides information about the exposure involved. For example, an application for an automobile policy, you would identify yourself, describe the automobile to be insured, and indicate the use of the automobile, where it will be garaged, who will drive it, and other facts that help insurers assess the degree of risk you represent as a policyholder. Some applications for automobile insurance also require considerable information about your driving and claim experience, as well as information about others who may use the car. In many cases, such as life insurance, the written application becomes part of the policy. Occasionally, before an oral or written property/casualty application is processed into a policy, a temporary contract or binder may be issued. Binders. As discussed in Chapter 9, Fundamental Doctrines Affecting Insurance Contracts, property/casualty insurance coverage may be provided while the application is being processed. This is done through the use of a binder, which is a temporary contract to provide coverage until the policy is issued by the agent or the company. In property or casualty insurance, an agent who has binding authority can create a contract between the insurance company and the insured. Two factors influence the granting of such authority. First, some companies prefer to have underwriting decisions made by specialists in the underwriting department, so they do not grant binding authority to the agent. The underwriting errors of an agent with binding authority may be corrected by cancellation if the policy is cancelable. Even with cancelable policies, the insurer is responsible under a binder for losses that occur prior to cancellation. If it is not cancelable, the insurer is obligated for the terms of the contract. The binder may be written or oral. For example, if you telephone an agent and ask to have your house insured, the agent will ask for necessary information, give a brief statement about the contract, the coverage and the premium cost, and then probably say you are covered. At this point, you have made an oral application and the agent has accepted your offer by creating an oral binder. The agent may email or mail a written binder to you to serve as evidence of the contract until the policy is received. The written binder shows who is insured, for what perils, the amount of the insurance, and the company with which the coverage is placed. In most states, an oral binder is as legal as a written one, but in case of a dispute, it may be difficult to prove its terms. Suppose your house burns down after the oral binder has been made, but before the policy has been issued, and the agent denies the existence of the contract. How can you prove that there was a contract? Or suppose the agent orally binds the coverage, a fire occurs, and the agent dies before the policy is issued. Unless there is evidence in writing, how can you prove the existence of a contract? Suppose the agent does not die and does not deny the existence of the contract, but has no evidence in writing. If the agent represents only one company, he or she may assert that the company was bound. But what if the agent represents more than one company? Which one is bound? Typically, the courts will seek a method to allocate liability according to the agent's common method of redistributing business. Or, if that one is not determinable, relevant losses might be apportioned among the companies equally. Most agents, however, keep records of their communications with insureds, including who is to provide coverage. Conditional and binding receipts. Conditional and binding receipts in life insurance are somewhat similar to the binders in property/casualty insurance, but contain important differences. If you pay the first premium for a life insurance policy at the time you sign the application, the agent typically will give you either a conditional receipt or a binding receipt. The conditional receipt does not bind the coverage of life insurance at the time it is issued, but it does put the coverage into effect retroactive to the time of application if one meets all the requirements for insurability as of the date of the application. A claim for benefits because of death prior to insurance of the policy generally will be honored, but only if you were insurable when you applied. Some conditional receipts, however, require the insured to be in good health when the policy is delivered. In contrast, a claim for the death benefit under a binding receipt will be paid if death occurs while one's application for life insurance is being processed, even if the deceased is found not to be insurable. Thus, the binding receipt provides interim coverage while your application is being processed, whether or not you are insurable. This circumstance parallels the protection provided by a binder in property/casualty insurance. Again, there are some key takeaways and discussion questions. We are now moving into Objective 3 of Unit 3, critique various aspects of agency law and doctrines affecting insurance contracts, beginning with the only reading, Agency Law, Applications to Insurance. Agents. Insurance is sold primarily by agents. The underlying contract, therefore, is affected significantly by the legal authority of the agent, which in turn is determined by well-established general legal rules regarding agency. The law of agency, as stated in the standard work on the subject, deals basically with the legal consequences of people acting on behalf of other people or organizations. Agency involves three parties: the principal, the agent, and a third party. The principal, insurer, creates an agency relationship with the second party by authorizing him or her to make contracts with third parties, policyholders, on the principal's behalf. The second party to this relationship is known as the agent, who is authorized to make contracts with a third party. The source of the agent's authority is the principal. Such authority may be either expressed or implied. When an agent is appointed, the principal expressly indicates the extent of the agent's authority. The agent also has, by implication, whatever authority is needed to fulfill the purposes of the agency. By entering into the relationship, the principal implies that the agent has the authority to fulfill the principal's responsibilities, implying apparent authority. From the public's point of view, the agent's authority is whatever it appears to be. If the principal treats a second party as if the person were an agent, then an agency is created. Agency law and the doctrines of waiver and estoppel have serious implications in the insurance business. Binding authority. The law of agency is significant to insurance in large part because the only direct interaction most buyers and insurance have with the insurance company is through an agent or a broker, also called a producer. See the National Association of Insurance Commissioners website and licensing reforms as part of the Graham-Leach-Bliley Act prerequisites discussed in Chapter 8, Insurance Markets and Regulation. Laws regarding the authority and responsibility of an agent, therefore, affect the contractual relationship. One of the most important agency characteristics is binding authority. In many situations, an agent is able to exercise binding authority, which binds coverage for an insured without any additional input from the insurer. The agreement that exists before a contract is issued is called a binder. This arrangement, described in the offer and acceptance section presented later, is common in the property/casualty insurance areas. If you call a Geico agent in the middle of the night to obtain insurance for your new automobile, you are covered as of the time of your conversation with the agent. In life and health insurance, an agent's ability to secure coverage is generally more limited, rather than issuing a general binder of coverage. Some life insurance agents may be permitted to issue only a conditional binder. A conditional binder implies that coverage exists only if the underwriter ultimately accepts or would have accepted the application for insurance. Thus, if the applicant dies prior to the final policy issuance, payment is made if the applicant would have been acceptable to the insurer as an insured. The general binder, in contrast, provides coverage immediately, even if the applicant is later found to be an unacceptable policyholder and coverage is canceled at that point. Waiver and estoppel. The agent's relationship between the insured and the insurer is greatly affected by doctrines of waiver and estoppel. Waiver is the intentional relinquishment of a known right. To waive a right, a person must know he or she has the right and must give it up intentionally. If an insurer considers a risk to be undesirable at the time, the agent assumes it on behalf of the company, and the agent knows it, the principal, the insurer, will have waived the right to refuse coverage at a later date. This situation arises when an agent insures a risk that the company has specifically prohibited. Suppose, for example, that the agent knew an applicant's 17-year-old son was allowed to drive the covered automobile and also knew the company did not accept such risks. If the agent issues the policy, the company's right to refuse coverage on this basis later in the policy period has been waived. In some policies, the insurer attempts to limit an agent's power to waive its provisions. A business property policy, for example, may provide that the terms of the policy shall not be waived, changed, or modified except by endorsement issued as part of the policy. Unfortunately for the insurer, however, such stipulations may not prevent a waiver by its agent. For example, the business property policy, which provides that coverage on a building ceases after it has been vacant for over 60 days. Let's suppose that the insured mentions to the agent that one of the buildings covered by the policy has been vacant 60 days, but also adds that the situation is only temporary. If the agent says, "Don't worry, you're covered," the right of the insurer is to deny coverage in the event of a loss while the building is vacant is waived. The policy may provide that it cannot be orally waived, but that generally will not affect the validity of the agent's waiver. From the insured's point of view, the agent is the company and the insurer is responsible for the agent's actions. This point came to a head in the mid-1990s when many life insurance companies were confronted by class action lawsuits that accused their agents of selling life insurance as a private pension. That is, when the investment portion or cash accumulation of a permanent life insurance policy is elevated to a position of a retirement account. There were also large numbers of complaints about misrepresentation of the interest rate accumulation in certain life insurance policies called Universal Life, which was discussed at length in Chapter 1, The Nature of Risk, Losses, and Opportunities. The allegations were that insurers and their agents furnished false and misleading illustrations to whole life insurance policyholders, failing to show that policies would need to be active over 20 years to achieve a comparable interest rate on their premium dollars, and used a software online computer program and other misleading sales materials to do so. These were dubbed vanishing premium policies because the policyholders were led to believe that after a certain period of time, the policy would be paid in full and they would no longer have to make premium payments. Though no vanishing premium case has been tried on the merits, litigation costs and settlement proceedings have cost companies hundreds of millions of dollars. Many large insurers such as Prudential, MetLife, Money, Northwestern Life, Life of Virginia, and more were subject to large fines by many states' insurance regulators and settled with their policyholders. Prudential's settlement with 8 million policyholders will cost the company more than $3.5 billion. Many of these companies created the new position of compliance officer, who is charged with overseeing all sales materials and ensuring compliance with regulations and ethics. Meanwhile, states focused on modifying the strengthening market conduct regulations. See the box Enforcing the Code Ethics Officers for a review of insurers' efforts regarding ethics and for ethical discussion questions. Ultimately, the insurer may hold the agent liable for such actions, but with respect to the insurer cannot deny its responsibilities. The vexing problem of vanishing premiums has proven to be an expensive lesson for insurance companies on the doctrine of respondeat superior, a Latin phrase referring to the doctrine that the master is responsible for the actions taken by his or her servant during the course of duty. Neither insurers nor regulators consider an agency relationship as an independent contractor relationship. Estapel occurs when the insurer or its agent has led the insured into believing that coverage exists, and, as a consequence, the insurer cannot later claim that no coverage exists. For example, when an insured specifically requests a certain kind of coverage when applying for insurance and is not told it is not available, that coverage likely exists, even if the policy wording states otherwise, because the agent implied such coverage at a time of sale and the insurer is estopped from denying it. Agency by estoppel. An agency relationship may be created by estoppel when the conduct of the principal implies that an agency exists. In such a case, the principal will be estopped from denying the existence of the agency, recall the binding authority of some agents. This situation may arise when the company suspends an agent, but the agent retains possession of blank policies. People who are not agents of a company do not have bank policies in their possession. By leaving them with the former agent, the company is acting as if he or she is a current agent. If the former agent issues those policies, the company is estopped from denying the existence of an agency relationship and will be bound by the policy. If an agent who has been suspended sends business to the company that is accepted, the agency relationship will be ratified by such action, and the company will be estopped from denying the contract's existence. The company has the right to refuse such business when it is presented, but once the business is accepted, the company waives the right to deny coverage on the basis of denial of acceptance. There is inserted text, key takeaways, and discussion questions. That concludes Unit 3 of Risk Analysis and Insurance.